there and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair like a big old murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Hello everybody, Excited Utterance here. My name's Hella, and yes, who said Flight of the Valkyries? That's Robin Fox. Hello, you are right. You are right. One of my favorites. One of my absolute favorites. I'm just going to turn down my Hella light there. Yes, my dad used to play me that from Wagner. Wagner's The Ring. A very, very long opera. Used to sit me down and make me watch the whole thing. 10 hours or so of opera. Welcome everybody. Welcome to another installment of Idaho versus Koberger document drops. Wow. They didn't disappoint. Happy New Year from the defense. And we are counting down to the 23rd of January, where there will be some pretty intense arguments happening. Goodness knows whether this is going to lead to a motion to dismiss from the defense. I don't know, but all I know is that the state really seems to have dropped the ball when it comes to their expert witness list. We're going to be talking about that pretty shortly. As the name of this stream indicates, what is going on with the sheath? What's going on with the DNA? Because the state seems to have missed out some pretty important experts. How are they going to explain that touch DNA, the DNA that is really the cornerstone of their case, right? Everyone's been talking about this sheath that supposedly puts him inside that house and stabby up the 4 people in the house. How you get stabbed with a sheath, I don't know, but the sheath supposedly that goes with the murder weapon, which is a K-bar knife, and it supposedly has his transfer or touch DNA on the little snap on there. Well, how do you explain DNA without a DNA expert? Who's ever watched a trial that doesn't have a DNA expert that supposedly is introducing DNA? I haven't. I'm just going to have a bit of a moment to say hello to people. Hello, Melissa Simok. Good to see you here, and thank you for being here. And I'm looking forward to covering this. There's some really cool docs today to have a read through. Happy New Year to you, Maddie B. Bill will explain it himself. Well, you know what? Bill seems to be the ultimate one-man band. He's not only busy at this time of year, recovering from doing all his rounds, dropping off toys to all the kids because he is Santa, but he's the expert among experts because he doesn't really seem to need any experts. He just does it all himself. seems he's a DNA expert as well. Sup, Justin Smith. Touch DNA is kind of garbage evidence, too easy to transfer. Look, I agree, Pink Slime, and a lot of people agree with you too. The problem is juries don't understand it because it's got the magic 3 letters, DNA. And DNA is irrefutable. And I heard Joe Scott Morgan, who is not my favorite person because he's friends with Nancy Disgrace. Joe Scott Morgan a little while ago was talking about this magical DNA that was on the magical sheath, which can hurt people. He was talking about it being 1 in 5.7 octillionth of a chance that it's somebody else. Well, how he knows that, I'm not sure. But they don't seem to have a DNA expert to come to trial and say that. Maybe they can't find one willing to put their reputation on the line. Or maybe they just forgot to put the expert on the list because the defense is saying that their list is pretty crap. Not just pretty crap, a lot crap. Because there's, I think, 20 or so of them are missing their reports to go along with, like, their CVs. If you've followed any pre-trial proceedings before, you'll know that there is a deadline where both parties need to put forth their experts, and not just the names of their experts. They have to put forth the CVs of their experts and their arguments. So what the defendant is going to face in terms of arguments so their experts can counter them. Doesn't look like the state's really done that. They've done it for a few of their experts, but not all of them. Not at all. And this is a capital case. This is no small thing, right? The state's trying to kill a person. They're trying to kill him. So, as we talked about when we had Steve Gosney on, he is an expert in the death penalty, defending clients against the death penalty. Death is different. Everything changes when the death penalty is on the table. The client is entitled to what's called maximum due process. Every single protection that is available to him is allowed. And this whole playing games of not providing information as to what these experts are going to put up against him, it's just not. It's not okay. It's not okay. Hello, Brooklyn. If DNA evidence was easy to understand, it would be used more often. But last major case was the O.J. Simpson. Good to see you, Brooklyn. Gosney spoke very well about this. I learnt so much that day. And from reading his latest book, which is called Death Penalty Designs. Snibbles is here. Good to see you. Erica Thorpe, good to see you. And Diane, good to see you. You know very much, lots about the case, heaps and heaps, and I look forward to your input today. You watched a YouTube video on it. You're an expert, are you? Well, you'd be more of an expert than anyone the state's bringing in because they're bringing nobody. Yeah. Okay, how about we get into it all? Let's get into it all. Right, so P.S. there is a poll going on. You might not know what that's all about. So we're going to look at the defense's subpoena first. And it's a very odd document. Odd. O-D-D. Odd. Because it's blank. How very strange. How very strange. So let's have a look at it, shall we? I like mysteries. Mysteries are good, sometimes not. Let's see. Okay, and I'm gonna, you know how I like my little graphics and things, so I'm just going to put over the top of it. Look at my pretty little overlays, aren't they pretty? Okay, so this one here is, let's see. It's called a subpoena tecum. I can't pronounce Latin things very well at all, but that's okay. Here we are. And it is State of Idaho plaintiff versus Brian C. Koberger to somebody. We don't know who. Look, it's blank. Blank, 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 blank. Kind of like a blank check. You are hereby commanded that, laying aside all excuses, you appear in the District Court of 4th Judicial District of the State of Idaho in and for County of Ada in Boise, Idaho on January 23rd, 2025 at 8 a.m. That's early, so you can't sleep in. Through the end of the hearing as a witness in the above entitled matter on the part of the defendant. So the defense is calling this person. You are further commanded in capital letters to produce or permit inspection and copying of the following documents or objects, including electronically stored information at the place, date, and time specified above, and more blank lines. Now, usually when things are redacted, what do we see? Right? We don't see blank lines, right? We see blacked out boxes. But we're not seeing that here. So I find this really strange. It's like, what's going on? If anyone can explain this to me, please tell me. Hey, Edge, how are you, mate? How are you? Good to see ya. I was on Andrew's stream the other day with DB and Michael. It was so much fun. And Fian, thank you for being here and thank you for becoming a member. I hope you're having a good day. I think you're streaming later, aren't you? Let me know and I'll chuck a link into your stream. Jewesses to come. Really? Okay. So yeah, isn't it weird? Isn't it really weird to have those blank lines there? And so I've put a poll up, guys. Let's have a little bit of a guess at who we think it might be. I'm tending towards it being a Fed. Reason being is the Feds have been so quiet. Like, we're up to now the defense, the people. I know the people's supposed to be state, but the citizens involved, we're up to the 21st supplemental discovery request. 21, right? That's a lot. And the discovery deadline was in September. What's going on? So the Feds have been really, really quiet. The CAST report, which is supposed to be the thing that shows all of the tracking of the phone, where it went, including not just cell data like phone calls and texts and things like that, but also the phone connecting to things like Google and all the apps, etc. This CAST report, I think it's still missing a lot of stuff, and that comes from the Feds. I have a feeling that it'll be somebody from the FBI who knows something and has just been not forthcoming with information. But that's just me. That's what I would vote for. People are talking on the Reddits, etc., about there being a confidential informant, and that might have been how they originally came upon Brian Koberger. But then again, everyone wants to hear from the roommate. Everyone wants to hear from either of the two surviving roommates. So it could be one of those. Don't know. You think that's just another way to redact writing? I don't know. I've not seen it before. You might be right. And good to see you, WIGDMA. I don't know if that's how you say it. You reckon it's a glowy? Could be. Yeah, seems likely. Hey, Pink Slime, English speakers got kind of screwed concerning Latin pronunciation. The whole world pronounced it one way. England decided to have their own unintelligible pronunciation. You voted someone else. specifically Mick Foley, aka Cactus Jack. Oh, Eric. Hey, Angel's favorite, everybody's favorite. Is that Steve? Not sure. I think it's Steve. Nice to see you. Nice to see you. Good to see you. Okay, let's keep going. Let's keep going. So, yeah, imagine getting that in the mail. You'd be like, oh, damn it. I had something on that day. Okay, next things next. Let's look at this one because this is the one that really gets me excited. This one is motion to compel ICR material and for sanctions. Sanctions, baby. Bring on the sanctions. If anyone deserves sanctions, it's the state in this case. So let's get into it. Sorry, I'll just go to the bottom and see which of the lawyers wrote this one. Anne. It looks like Anne wrote it. She's first. Okay, cool. All right. They're all just like firing shots at state through all of their motions that they've dropped in all of their responses, that they've dropped in the last day or so. So got to give credit where credit's due. Hey Bobby, how are you? The sheathless. Okay. Comes now, Brian C. Koberger, by and through his attorneys of record, and hereby moves this honourable court for an order to compel complete expert disclosures. All right, so this is what I was talking about before, about how the state has been really kind of lazy and shoddy with their list of experts from the state in this manner, and requests sanctions pursuant to ICR, so Idaho Criminal, I can't remember what that is, record, should be criminal records, 16K. Sorry for being a useless bugger and remembering what the acronyms mean. The bulk of the state's expert disclosures fail to include opinions and reports. These inadequate disclosures greatly prejudice Mr. Koberger, who is obligated to submit defense guilt phase expert disclosures by January 23, 2025. Goodness me, right? So he's supposed to submit defense guilt phase expert disclosures in a couple of weeks, right? So keep that in mind. The sanctions considered must be exclusion of the experts at a bare minimum, an order compelling proper disclosure, and an extension of Mr. Koberger's January 23, 2025 deadline. So they at the very least, they want that deadline extended. At least. Mr. Koberger is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront. Relevant facts, let's go. In this case, there are over 68 terabytes of discovery produced in a method that the defense has repeatedly referenced in pleadings and at various motion hearings as extremely disorganized. Yes, they have. And I would go so far as to say that the state has no idea what's in that 68 terabytes of discovery. Every time they get asked what's in there, they're like, oh. They get this blank look on their face. Absolutely. They just keep handing over the same chunk of data. I think they put it on a Dropbox or something. And they get asked questions about it. They're like, it's the same thing we handed over. We checked it. It's ridiculous, absolutely ridiculous. And guys, remember when we did the stream about Luigi just recently, and the prosecutor was all up in arms about there being 2 terabytes and how it might blow up the portal? There's 68 terabytes for you. There have been 20 specific requests for discovery and 6 motions to compel filed by the defense. Well, make that 21. So since then, there's been another one. The court entered a redacted order governing further criminal proceedings and notice of trial setting on October 9, 2024, and has notified the parties that strict compliance with the court's order is expected. On December 18, 2024, the state disclosed 25 experts. Okay, so December 18, here you go, have our 25 experts. Of those, only 5 included actual expert reports. What? Excuse me, what? Only 5 included actual expert reports. I am very good at maths, but 25 minus 5 equals 20. So where are the other 20 reports, state? Where are the other 20 reports? Where are they? What are you doing, people? You're trying to kill a man. You're trying to kill a man. And you just chuck 20 other names out there and you haven't put the reports with them? What are you doing? This is disgusting. This is disgusting. Right? Hey, AG, how are you? Oh, Mavka. Hey, woman, how's it going? Woman, my lady. This is ridiculous. What is going on with that? Right? Okay. Now, here's the kicker. Here is the kicker. Get ready. Notably, not a single DNA expert opinion or report was produced. What? Excuse me, what? What? Not a single DNA expert opinion or report was produced. Wow. Okay. So nice, Anne, for dropping that one in and letting us all know. Thank you. I love how the defense does this, right? Every now and again, they'll drop something in to make sure we out here all know what the state's been doing and what they're missing, right? So there's just that little sentence dropped in there so make sure that we're all aware that the state hasn't got anything. And that sentence there, thank you. Isn't that interesting? So how are you guys going to bring in this sheath with no expert opinion about the DNA? Are you just going to go, well, you know what? We found this sheath and we watched a YouTube video, yeah. And we got, remember Detective Mowry? Remember how he took some screenshots and went, yeah, bro. Maybe they just got one of their law enforcement officers, one of their detectives to do a little quick course. Maybe that's how it worked. They just need to find an expert to write the correct opinion. Well, looks a bit late because they're well past the deadline now. What are they going to do? All right. Instead, the state's disclosure refers to Bates numbered pages and say, this disclosure is provided as an aid, and it does not encompass all findings, impressions, conclusion, or materials related to this expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. Further, this expert may testify about findings, impressions, and/or conclusions that he/she drew from the work of other experts who previously examined or handled the evidence in question. What the hell? What? So of the state's disclosures that have been provided, you're putting this caveat on there and going, well, you know what? they can go and say whatever they like about other people's opinions as well. This is just bullshit. This is complete bullshit, right? So just because we feel like it, because we're the state, so we can just get our experts to put other stuff forward that you don't know about after the deadline, and it can even include drawing from work of other experts who previously examined or handled the evidence in question. Right, AG? Like, you're a scientist. That's crap, right? That's absolute bullshit. This is so bad. I mean, am I misreading this? Tell me, like, someone pull me up if I'm misreading this. This is bullshit. This is bullshit. Right? Okay. At least 3 digital forensics experts are disclosed with lists of 67 electronic devices or third-party databases examined. Not a single report of what the 3 experts will opine related to any specific device or data is disclosed. So they're just like, okay, well, we found these digital forensics people and here's their CVs, but we don't need to tell you what devices that they're going to talk about. You can guess. How about we have a guessing game? It's just a death penalty trial. That's fine though. All good. All right, now we get into the meat, because this is fun. I like this. I like it when they get nasty. Argument. This is a capital murder case, and nothing about it is clear cut. The expert issues are complex, involving many different facets of DNA, cellular data, cell tower coverage, and drive testing, car identification, crime scene, and blood spatter analysis. Yes, it's spatter, not splatter. There's been, in a different case, Richard Allen, I think it was it Holman that was saying splatter? Fingerprint analysis, forensic pathology, and electronic device analysis of the suspect, victims, and alternative suspects, and social media accounts. Yes. Jerry Holman was the splatter. Perpetually, he can't work it out. You just take the L away. It's not that difficult. At issue is the state's supplemental response to requests for discovery regarding expert testimony and its exhibits, filed December 18, 2024. The disclosure lists 25 experts and provides curriculum vitae, so CVs, 5 with expert opinion reports. That means 25 minus 5, everybody. And others with reference to base numbered pages or items, but no opinion, data, or methodology. What the state's disclosure does not do is follow the rule which states, okay, so here's the rule. Idaho criminal rule, R is for rule. Expert witnesses on written request of the defendant. The prosecutor must provide a written summary or report of any testimony that the state intends to introduce at a trial or at a hearing pursuant to Rules 702, 703, or 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Well, they got one bit. Witnesses' qualifications. Great! Disclosure of the expert opinions regarding mental health must also comply with the requirements of Idaho Code 18207. The prosecution is not required to produce any materials not subject to disclosure under subsection G of the rule. This subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or the witnesses' qualifications, intended only to rebut evidence or theories that have not been disclosed under this rule prior to trial. So, as the Court of Appeals has held, the plain text of Rule 16b(7) requires the disclosure of expert witness opinions, the facts and data for those opinions, and also any testimony that the state intends to introduce pursuant to Rule 702, 703, and 705 of the Idaho Rules of Evidence that encompasses not only an expert's opinion, but also scientific, technical, or other specialized knowledge to which a qualified witness may testify in a form other than an opinion. Okay, so what is going on? What is going on? How are there 20 experts with no reports? And we are, what, 2 weeks, 3 weeks out from a deadline? Not even that. Was it the 17th? Or was it the 23rd? Let's go back. When is their deadline? January 23rd deadline. So it's actually the same day as the hearing. Mr. Koberger's deadline is the 23rd. So how is he supposed to respond to 20 of these without knowing what they're going to say? How? Right? It makes no sense. No sense. Okay, so they're going to state some case law now. State versus Marin, 158 Idaho 622 625. As the court explained in Marin, when an expert relies on some form of scientific or technical information that must be disclosed, as opposed to other witnesses whose opinions may be of the less scientific variety, the discovery rules are designed to safeguard the truth-seeking functions of trials. Oh, wow, well, imagine that. Truth-seeking. It'd be good if that was what the state was trying to do, generally, find the truth. Truth would be good. Truth-seeking functions of trials promote fairness and candor, to facilitate fair and expedited pre-trial fact-gathering, and to prevent surprise at trial. No one likes surprises, do they? If the state violates a disclosure requirement under ICR 16b(6), the trial court has considerable discretion to fashion an appropriate 16K remedy. State versus Montgomery, 163 Idaho 40 2017. Before we go on, I just want to look at this footnote. Mr. Koberger is filing Exhibit A under seal containing the specific issues with the disclosures. Courtesy copies will be provided by email. Okay. Sometimes they hide little interesting things in the footnotes. And thank you to Mr. Ilya Dali Talk, for the gifted memberships. 1, 2, 3, 4. How very sweet of you. How very sweet of you. Thank you very much. Welcome, new members. New members, make sure that you go to the membership tab and click on the little link that will take you over to our Discord. We have good fun in there. All right. Now, I do like this next sentence. Mr. Koberger continues wading through a sea of discovery. Nicely put. The need for rule-compliant expert disclosures is critical to his ability to prepare for his defense at trial. No shit, Sherlock. The state's failure to comply is not harmless. Now that's interesting wording, not harmless, because at appellate stage, you know what appellate courts like to do? They go, well, that was harmless error. Didn't cause you any problems, and we're not going to grant your appeal. So he's saying this is not harmless. This will cause harm. Very important word. Oh, calm the farm. Okay, conclusion. Mr. Koberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's trial-setting order. The expert evidence disclosed by the state is woefully inadequate. Woefully. This is a capital murder case, and compliance with the rules of discovery are not optional. Oh, this is getting serious now. Mr. Koberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23, 2025. Wow. Okay. So, what do you think, guys? What do you think of that? I'm going to say something interesting about Hitler now. I did a stream about Hitler about a month ago, giving my sense or my ideas about how I feel he is in terms of what he's likely to do next. I think this is his big moment, right, to prove whether or not he has any balls. Because I said he's kind of got no balls so far, right? He seems kind of fair and kind of he likes his home turf advantage in that he can bark, but his bark is worse than his bite, right? But now he's being put on the spot because this is pretty clear cut. There are 20 experts that have been put forth with no reports. That's just maths, right? That's just flat out maths. If he doesn't do something about this, and again, like Ann Taylor has said, this is a death penalty case. He's actually never presided over a death penalty case before. He cannot not do something about this. He must do something about this, right? So let's just see how he responds to this. He must extend the deadline, and he must sanction the state in some way. He can't just let them get away with this. He can't, right? And as far as the DNA experts concerned, well, is he just going to let them bring somebody in after the date? I have a feeling that the state's going to say, oh, whoops. Yeah, no, we have someone. Yeah, we do. It's, whoops. Here you go. Right? I think the sanction is going to be death penalty off the table. I think they're going to lose the death penalty over this. And yeah, that deadline's going to have to be extended, obviously. So that is my prediction as to the outcome over this argument. But we'll see. I'd like to know in chat what you guys think. But yeah, this is just ridiculously bad. And it's symptomatic of what the state has done up until now. So let's keep going. There are more. There's more documents. Goodness me, it keeps going. By the way, this is the defense's 21st supplemental request for discovery. 21. Good old 21. And R&M is gifted an excited utterance membership. Thank you so much. Oh, wow. Hi. Thank you. I really appreciate that, love. Sleuthy's in chat. Hey, Sleuthy. How are you? Mate, if you want to pop on, you are welcome. You know so much about this, and anything at all that you can do to contribute to the conversation, I am so open. I'd love to chat with you. I'd love to chat with you anytime. If you can't, cool, but maybe another time. Really appreciate you being here. Anyway, yeah, let's keep going. Mother Goose. Yes, she is Mother Goose. Okay. War. War. Okay, cool. And hey, criminality's here as well. Hello, T. How are you? Nice to see you. Welcome. Welcome. Still don't understand how they have Koberger without the DNA evidence. So what am I missing? What do you mean without the DNA evidence? It's a bit of a chicken and egg situation, isn't it? And I think we're all confused a bit about all this. But we'll come back to that. If you send me a link, I can talk while I'm driving and getting Bubby ready for bed. Oh yeah, let's go. Let's go. Let's go. Let's bring her in. All right, invite. I will pop it over to X for you. Just a minute. Yeah, I need to find you first. I need to find you first. Give me 2 seconds, guys. I need to invite Sleuthie. Sending you a message. There you go. Cool. There you go. Woohoo. Done. All right, there it is. Cool, done. Okay, let's move on to the first of the responses to the state's objections to the motions to suppress, because they're pretty interesting. Alrighty, and oh, there she is. That was quick. Hello.
I feel bad. I like derailed the whole show.
You're right.
What are we talking
Welcome.
about besides Brian Koberger?
Nah, that's it.
Well, specifically what?
Okay, well, we're going to get into the the defense's responses to the state's objections to the motions to suppress. So I'm about to get into that now. I am just going to bring one up. Here we go. Just have instead. All right, so we've got this one, the one where we have 1, 2, 3, 4, 5 of them wrapped up together, and no arguments made an objection, thus no reply needed.
I was gonna say, what is it? Just me that felt like when I was reading all of those, their objections to the suppression of all those things, it seemed like a copy pasta. Like all of our, it's just you should say no. That was the gist of each one for the same. All of them are
Right,
the same thing.
right.
I
Okay,
had to keep
so
checking.
exactly. So everyone knows basically what's happened so far is we've had motions to suppress the all of these things. So motions to suppress the arrest warrant, a search warrant for Mr. Koberger's person, search warrant for Mr. In Pennsylvania for Mr. Koberger's person when he was there in Pennsylvania, search warrant for the defendant's apartment in Washington, and motion to suppress Pennsylvania search warrant for the white Elantra. And those motions to suppress happened a couple of months ago, and then the state obviously objected to those motions to suppress. Those objections were pretty lame, let's say, without going through them in detail. And the defense has just come back with this one document wrapping up all of those together. And is it Eliza? Yeah, Eliza has said, you know what? No arguments were made in objections, thus no reply needed. Right?
Yeah, he basically was like, no, I don't agree with this. No, that was it. But
Yep,
I mean, let's
that's
be
it.
real though. It'll be enough. Like it'll be enough. It just will be, unfortunately.
Do you think so, Sleazy? I want to get your thoughts on that. Do you think that Hitler's just going to go, okay, and uh, denied?
So I think that I have two thoughts. I When I watched the first hearing with him,
Mm.
And even when I first heard that it was moving, I immediately thought that this was not going to be good for the defense. But I'm sure Anne sat there and, was like, the odds of us getting like a Fran Gull, are they worth having this happen in a different jurisdiction? Like, is the need for us to move out of this place strong enough to have a chance that we end up with a Judge Gull?
Mm,
And she decided that it was. And so, um, I think that they were not going to get another judge. And so then
no.
when I saw this guy, I was like, okay. I mean, he's very firm, which I think was lacking.
Yeah,
And
definitely.
I just don't. Yeah, I think that the defense would have gotten used to being able to explain everything, like with expert witnesses and going in person and just being very thorough about arguing their points rather than relying on them coming just simply from the filings. And
Mm,
now I think there's going to be a big reliance on the judge on what's filed versus what he hears as testimony. Like, I don't see this judge having a hearing every 5 minutes over each little
no,
argument. You know what I mean?
no. He said that. He said, I get things done quicker. He threw shade at everybody, basically,
He
right at
did.
the start. He did. Um, and he, look, I have a feeling, though, when he's confronted with something that could be overturned, he won't want that, right? Like, he's only ever been reversed on a motion to suppress.
Yeah. Well,
That's it.
so then you're in his extra concerned territory with these. And
Yeah,
do I think he'll come back and say to the prosecution that, like, they have to give an answer? Like, you need to file a response to this that has actual case law in it. Yeah, maybe.
mm,
Um, but if they don't, do I think he's just gonna, like, as a repercussion, suppress all of this? No, I don't think so.
yeah. I'm. This is his moment. Like, this is his moment to show whether he's just going to be a complete simp for the state or not. As far as I'm concerned, I don't know. It's so interesting to see whether or not he is going to play games. But I feel like he's one of these judges who he likes to sort of puff his feathers out and say, "Look, I'm so in charge."
Oh yeah,
Um, but I think underneath it he's he knows where his place is in the hierarchy of things, and he's a trial court judge, and he'll only make certain rulings. He'll leave other things for the appellate court, and that's like we saw with the death penalty motions. None of those were going to be sustained.
yeah,
None of those. Yeah, it was really obvious. Um, people were people were talking about, oh, the defense did a bad job, and they didn't do a great job, but the actual motions themselves were fine. They were good.
well,
They
people also don't consider the fact that, like, the defense, and not just this defense, but like a defense, often has to file certain, like, filings to be effective. It doesn't mean that they have these bombshell arguments every single time,
yeah
but they still got to file it. They have to try to get that off the table, um, especially if they have any evidence that would even somewhat support it. But I think this
yeah
idea that defense attorneys and sometimes even prosecutors don't have
yeah.
this thought in their head as they're filing something, that, like, there's no way this is going to get approved, is just silly.
Yeah. Well, I mean, I don't know if you watched when I had Steve Gosney on to talk about the defense motions for death penalty, but he took one look at them and he was especially the one that was titled just motion to strike death penalty, the one
Yeah.
where we had the tension between the two constitutional rights. He was very impressed with that one, but he said, like, none of these are going to get approved at trial court level. These are all the audience for these is the appellate courts,
Yeah,
and
exactly. And you still have to make a good argument, but
yeah,
even if you know it's not going to be approved. I'm curious your
absolutely,
thoughts. I know we're talking about the suppression ones,
yeah,
but prior to this, when the Franks stuff came out, like, what are your thoughts on the defense filing their Franks motion and memorandum? Well, the motion I think was public, but it was very bare.
yeah,
But the memorandum was filed under seal. What are your thoughts on them choosing to file that under seal? And I'll say, just from my point of view for a second, I
yeah,
think that this whole deciding which things we want to make public and which things we're going to file under seal for whatever reason, I think it's more harmful than helpful. I think that,
yeah,
for instance, the Franks memorandum, it's my opinion that I don't know what harm when you realize what kind of accusations have to be in the Franks memorandum.
yes,
I don't see how it would harm Brian Koberger, and why the defense wouldn't want to get their information out to the public, especially when they've complained so much about, and not, I'm not saying they have no merits to complain about it, but
mm,
especially after complaining so much about the state putting out this information and how prejudicial it is, I just wonder why they would choose to file that under seal as opposed to, we want the world to see what all
I
happened here,
have
what we think happened here.
look. I don't know. There's all I know is Ann Taylor knows what she's doing. So I have to my faith in her and go, well, maybe she's opening the door to something that could be in some way prejudicial. The rumor mill on the internet, the way people spin things against her client, it's rampant. So maybe she knows it's going to come out eventually anyway. So it's just best to keep things within the confines of the courtroom for now. Maybe. I don't know. Maybe that's the way she's looking at it. I can't explain it. I agree. Transparency is better. And it's a Frank's motion. It's about there being wrongdoing done by the
Right.
police,
Yeah.
by the state. It shouldn't have anything in it that could prejudice him. But we just have to trust her, I suppose.
Unless
There's
there's information that the public does not know, that you have to put
mm,
in there, that you don't
yeah,
want them to know, and the whole
mm,
purpose is to get certain things suppressed, so maybe having it out there, at all, is something you don't want. But
maybe,
I don't know.
maybe. I mean, look, maybe, but I feel like more than likely it's something that is, yeah, something that you don't, she doesn't want people to know, but it's not necessarily inculpatory. It's just something that could sound bad,
Yeah.
right? Like, I still have a real problem with the way they wrote the alibi document in that they include stargazing in there. Like, that was a stupid thing to write. Like, people just took the word stargazing and ran with it. Who cares if he was stargazing? He was 40 miles to the west, right? Like, people took stargazing and turned it into this giant thing, like, oh, queer stargazing, right? Like, if there's something like that in there, and maybe a little bit worse, that people can take and turn into sort of a meme in some way, then like your Nancy Graces will just make it into a story.
We know how I feel about her.
Yeah, it'll become part of the part of the soap opera. Exactly, part of the dish glove soap opera.
Here, my all-time favorite thing. I'll never forget it. Someone actually commented on like one of my videos where I actually played it then in slow motion because I couldn't believe this woman said it. But
Mm,
one of my favorite things that has ever been said, and it'll be hard to beat, is that
mm.
crazy woman saying that Brian Koberger is vegan or vegetarian or whatever because he's scared if he eats meat, he'll engage in cannibalism. And I just thought, what?
What?
What planet am I on right now where we're taking these enormous leaps in logic? So is everybody who doesn't eat meat or things that have been killed, is it because they are scared that they're going to eat people? That is the most insane thing I've ever heard. So yeah, like,
Oh,
stargazing.
and
Hard tell what she'd say about that. Lord have mercy.
sleuthy, and we're the conspiracy theorists, right?
Oh, people are so fixated. She is a doctor, and she is, and I just thought, this woman has testified against people. Are you serious? I'd be clipping that for all future hearings. Like, is what this woman's saying really? Like, what are the odds you get a vegan on the jury? Because then I'm playing that. I'm playing that. I'm saying,
Yeah.
she thinks people that don't eat meat are scared they're going to eat their families.
Well, I've thought about it.
That is so crazy to me. No, Nancy didn't say. It was that Dr. Carol Lieberman. Share her name.
Carol
I lose
Lieberman,
it.
yeah.
Yeah, I lose it, and then it pops into my head. Yep, Carol Lieberman. Yep, News Nation. Yep.
That's too funny. News Nation, they need to just die in a fire. Sorry.
You know the face that face that Vinny made, the reaction that he had to Doug Carter speaking at that press conference. Like,
Yes.
how is that not the reaction of the host? Like when she said that out of her face.
Yes.
Oh my
Eric,
God.
I eat my neighbors if there's meat shortage.
Oh my God.
Oh my God. All right. Do you want to do this document? So we've
Yes.
got Pennsylvania warrant for 119 Lambston. Okay. So, uh, so for those who don't know, when they arrested Brian Koberger, he was actually at his parents' house in Pennsylvania. So they decided not to arrest him just at a normal time of day. They decided to arrest him in the middle of the night, as you do. And they decided not to just like knock on the door and go, "Excuse me, sir, would you like to come with me?" They decided instead to ram through the front door with, snipers and guns and make a big hullabaloo. Because why not? That's more fun.
Well, I do have to say, in terms of executing an arrest warrant like that, I'm torn two ways. Number one, I think it's a little unreasonable to not consider the fact that if they can serve an arrest warrant at a time of day or night when you're going to be taken off guard, like you
Mm,
would at 3 o'clock in the morning,
mm,
um, to expect them to instead do it when you're out and about and there's other people around, potential
mm,
casualties, things like that. I
mm,
think that it was reasonable to do it, in the middle of the night. However, what I don't think is reasonable is that they were watching him, like, through the windows, and like, the only reason I could come up with there, if he was up and walking around, if he wasn't doing anything like
mm,
actively getting rid of evidence or things like that, or arming himself with a bunch of guns, then I don't
mm-hmm.
I would be curious why they chose right that very moment. But
Well,
why not wait
okay,
till he
so
goes to
they
bed?
did. I just don't understand why they couldn't have done it during like earlier in the evening, or I just don't understand why they couldn't have knocked on the door. What knock on the door?
Oh, that's going to be a
They
big
could have,
problem.
yeah, just knock on
Yeah.
the door. What's the big deal, right? Like they had the place surrounded anyway, so it's not that difficult. All right, let's have a look. Comes now, Brian C. Koberger, by and through his attorneys of record, and respectfully submits the following reply to the state's objection to his motion to suppress and memorandum in support re Pennsylvania search warrant for 119 Lambston Drive, Albrightsville, PA, and statements made. Okay, and so he must have said something when they picked him up, and fair enough too. Never talk to the cops, guys. First, it appears that the parties are in agreement. I like it when they do this. Okay. It appears we're in agreement, everybody, about some things. It appears that the parties are in agreement on much of what law applies to the search of a home. Several topics Mr. Koberger addresses are more fully developed elsewhere, and his replies to those will be filed in other replies, i.e. Frank's, IGG, Apple, Amazon, and AT&T records. That leaves the issue of how federal and Pennsylvanian law enforcement conducted their raid. The state tries to draw out its facts section by restating things several ways on pages 6 and 7 of its objection, but it basically boils down to, we knew he was in there and owned a gun, which of course is true of most Americans. The state cites to not a single case similar to the facts here. Okay, so they didn't provide any case law. Instead, the state relies on a memorandum written by Police Sergeant Lang of Pennsylvania. Now, Kathy from Indie Zone, you should listen to her podcast, by the way. She mentioned also, we've not heard this name before. This is new. His name hasn't come up yet, right, Sleuthy? You haven't heard of this one?
Is he not the one who did like a very brief interview right after arrest where he was like, he was in his underwear separating trash? And
I thought you meant he was in his own way.
Oh no! And the thing that he said, the thing that they claimed that Kohberger said was that he asked if anybody else was arrested or whatever. I thought it was I'm picturing him sitting at the desk. Somebody else might know, but I picture a man sitting at a desk and he's like, I wasn't there, but this is what I was told by my like officers that were there.
All right, that's a good one. We'll go look for that because Kathy said that he's not come up in any documents or anything up till now. This is the first. Like there were 2 other officers, but this one first mentioned. So.
Well, now while you read, I'll have to go look.
Yeah, see, I sent you on a little sleuthing game.
Just a small side journey.
Name. Just a small side journey, yeah. Okay. Rightio. So, Sergeant Lang of Pennsylvania State Police, apparently to justify their actions. So, this odd document, I love this odd document, never before disclosed, appears to have been written in response to Mr. Kohberger's briefing and includes no date. Well, it has to be an odd document if it's got no date. Basically, the police tell us they had to destroy the house to save the car or some other evidence from Mr. Kohberger's rubber gloves.
Yeah, no. We already know they're trash pickers, so, I mean...
Yeah. What the hell is this? No legal authority is provided. This is hilarious. I love it when they throw shade.
Yeah, I don't think that anything that the state is going to be able to say is going to explain why they executed a no-knock warrant, which is not allowed to happen in Pennsylvania. So I think regardless of anything, whether he had a gun, whether he had gloves that they thought he was going to throw down the toilet or whatever, I don't know, whatever, they went in, they didn't knock. They just busted all the windows out. You can't do that.
Not the gloves. Oh my God. Did you see that episode of Nancy Grace where she did the whole glove thing and she picked up her cup with gloves on and she's like, I just need to get my cup of coffee with gloves
because I no longer watch Nancy Grace because she is my arch nemesis. She blocked me and I boycotted her.
She blocked you. I did a reaction video to the gloves thing because I couldn't help it. It was too funny.
My reaction videos seem to get taken down.
See, you've made it. You've made it, Sleuthy. You see, I'm too little. No one knows me. When one day, someone will recognize me well enough to strike me down. Okay, so no legal authority is provided. However, given that this statement now exists, the court can compare this scenario with any number of cases. Just a couple of examples. US versus Gaither, 871, 994. Forcible entry upheld where police loudly announced but could hear sounds consistent with a constructive refusal and the subject was suspected of murder and believed well armed, right? Cornegay versus Cottingham, and that is 1997. No knock entry found unjustified where suspect was suspected of murder. The murder weapon, a handgun, was missing and he had a history of drug dealing and violent crimes. Okay. It's happened before, guys. All right. So here the police were concerned about making a hasty knock and announce, which apparently meant no knock and yelling from their bearcat. Guys, what's a bearcat?
Is that the big is it the big like thing they ride in on?
Yeah, I just like thought it must be an American thing. Sometimes I see these words and I'm like, I have no idea what that is. I assume, yeah, must be a police car of some sort. A tractor thingy. Bearcat is, oh, thank you, CH. Bearcat is the tank-like vehicle.
Yeah.
Almost a tank. Really, they came in like a tank?
That's what I thought. Yeah, it's like a big metal bulletproof. Yeah. And they all ride in
He's
it. Like it's got no seats. It's just got like benches and they all just sit in it together and they get out at the same time. Yeah.
he's one dude visiting his family.
It's so funny because they probably could have knocked and like I could see his dad, his
Yeah.
dad just like opening the door, like in his
Like,
boxers.
hey,
Yeah.
yeah. Can I help you? Goodness me. Okay, so because Mr. Koberger was wearing the same gloves, millions of homeowners wear to do the dishes. I love the way they put that. I love the way they write that. That's just brilliant. Two more things of note. According to the police, they had snipers watching Mr. Koberger go from room to room, obviously greatly reducing his chance of posing much of a threat. Can you imagine that, people? Right? Snipers. This is in a gated community, just a regular suburb. They had snipers getting about, right? This is like a movie. This is like a goddamn movie, right? They're walking around in the bushes and like,
Yeah, except if it was a movie, it'd be on camera, and they don't have any of this on camera. So
and that there's no body cam of
hmm
this,
that's a
right?
huge problem for me. Yeah.
There is why is there no body cam of this, right? Bullshit. There's no body cam of this. It's gone. Why? Either they just turn them all off or they have it and it's gone. This is crap. And although the state, I love the way although the state oddly claims it is not true, it's not true. The FBI had been surveilling Mr. Koberger since December 21st and had many occasions to take him into custody. Right, so December 21, right? The state had identified Mr. Koberger on December 19, 2022 through investigative genetic genealogy, guys. So if you hear IgG, that's what it means, investigative genetic genealogy. The state had obtained aerial photographs of the Koberger residence on December 21, 2022. The state had driven by the Koberger residence on December 23, 2022, and followed Mr. Koberger on December 24, 2022. Lovely Christmas present, isn't it? Cameras were placed on the parents' property on December 25. Oh, nice. Jingle bells. And trash was taken from the property on December 27, 2022. The state seems to accept that a failure to abide by law, I love this. So guys, you accept it, right? See, you seem to accept it. The state seems to accept that a failure to abide by law as to knocking and announcing leads to the exclusion of what was found in Mr. Koberger's parents' home. This court must suppress this evidence. Well, let's see. Moving on to the next one. What else do we got? What do you guys think? They could have scoped him whilst he was running in the neighborhood unarmed. Okay, so like Sleuthy said, if he's out in the public, I suppose that gives the possibility of there being like people walking along who could get injured, I guess. I just can't get past why they couldn't knock. How hard is that? Like, how hard is it to knock you? They had the place surrounded, right? They clearly had it surrounded because there were snipers. Right? So it wasn't too hard to put snipers around the house. So you have police around the house. Knock on the damn door. How does trash get taken in rural PA, get to Idaho, sorted, swabbed, and DNA run in 24 hours?
It
Sophie,
doesn't.
can you answer that?
It
Yeah.
doesn't. I have no idea what they did, but it just doesn't. Even if it's rushed, it doesn't.
See, I'm really sus on this. I think that they got something at an earlier point. I think they got something around the 13th to 15th.
I just wonder if they didn't get the full. Like, what would it take to say that these two profiles, the one that was in the on the sheath and the one that was
Mm.
in the trash, what would it take to get just a basic low level determination that they were biologically connected males?
Mm. Yeah, how much do you need?
Like, you do you just need to like create the profile and look at them side by side and count, 5 things that are the same, and that's good enough
Mm.
for now? Or do you
Mm.
have to like physically match both? Like, I don't know. But I also, it took them longer to get him back to Idaho than it did for them to send DNA in the middle of the night, um and have it processed, and no. I'm suspicious on it too, but they had to have gotten it from
It's
the trash.
the dates just don't line up. They legit, they're all over the place. Um, hey, MGP B87, they were disingenuous in how they requested a cell site simulator in the second AT&T warrant on December 23 when they already had eyes on and were able to watch him go from room to room. Yep. Okay. Yeah. CH, it's magic. DNA does take a while. It takes more than that. I feel like there's an informant somewhere who decided that it was him or gave the name, and then they reverse engineered it. That's just my feeling. Yep. And yeah, Brian is getting Richard Allen by the judge. But the judge isn't involved this time. Yes, the judge isn't involved this time because the judge is coming in far too late. But the question is whether the judge allows all this to be allowed in. Now, we'll see. We'll see. Okay, let's move on to the next one. Take your pick. What do we got? Motion to suppress ATT warrant. We might as well have a look at that. Boop, 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 boop. Oh, here we go. Okay. Comes now, Brian C. Koberger by and through. Oh, you got a spelling mistake, guys. Come on. Through his attorney's record and respectfully submits the following reply to state's objection to defendant's motion to suppress and memorandum in support regarding the AT&T first warrant filed with the court on December 6th. The words proof upon oath are not synonymous with the affidavit for search warrant, and its exhibits are hereby incorporated. A non-particularized general affidavit in support of a search warrant held in the hands of law enforcement, which never accompanied the electronically served warrant, cannot be relied upon to validate a warrant. So, the issue addressed by the state relating to this motion is that of particularity. Mr. Koberger maintains his argument as laid out in his opening memorandum and provides additional argument as the state's objection is limited to the argument regarding particularity, right? So, basically, hang on, we'll just keep going before I explain a little bit more. The Fourth Amendment requires particularity. So this is about being very arbitrary and broad with their search warrant. So they did an AT&T search warrant, and they did a bit of a sort of catch-all search warrant, and the defense is saying you can't do that. It's a Fourth Amendment violation. So the particularity requirement's objective is that those searches deemed necessary based on a probable cause determination by a magistrate should be as limited as possible, State versus Teal, 2008. The particularity requirement means that a warrant must be specific enough to enable the person conducting the search reasonably to identify the things authorized to be seized. I think that should be seized. US versus Spilotro, 1986. Mr. Koberger is aware that the Supreme Court has acknowledged that a court may construe a warrant with reference to a supporting application or affidavit if the warrant uses appropriate words of incorporation and if the supporting document accompanies the warrant. And then we have some more case law, Grove versus Ramirez, 2004. The AT&T warrant was void of any language that the affidavit was incorporated therein. See State's Exhibit S2, page 1, and we don't get to see those. The state relies incorrectly on, sure she'll be back, on Adamczyk versus State, which upheld a warrant where the opening paragraph of the warrant unambiguously referenced the affidavit and sworn testimony of Detective Sellers as the basis for the warrant. 163 Idaho 114125. In this case, no such words exist in the warrant. The affidavit nor any of its exhibits were incorporated. The warrant was served remotely. The affidavit was not made part of the search warrant. The officer served the warrant, did not attach the documents. My God, what's going on? The officer serving the warrant did not attach the documents that may have provided clarity. So she'll be right, mate. Here in Australia we go, she'll be right, mate. He'll be fine. He'll be fine. Those documents are therefore included in this filing as attachments. I'll do it for you then, shall we? Where a supporting affidavit does not accompany the search warrant at the time of execution. That's a bad word. The detail set out in the affidavit does not cure any deficiencies. US versus Pilling, Idaho 2024. Ooh, recent. Warrant suppressed where supporting affidavit was not provided to Apple. An affidavit is considered to be part of a warrant and therefore potential curative of any defects only if 1, the warrant expressly incorporated the affidavit by reference, and 2, the affidavit is either attached physically to the warrant or at least accompanies the warrant while agents execute the search. So, right, so here we go. In this situation, the warrant contained a broad sweep of all kinds of information relating to location information, tower connections and handoffs, other location programs, messaging, calls made, and account information. The request was a wide sweep. That's a problem. DB is here. Hello. How's it going, mate? They're not allowed to do a wide sweep. They have to be specific. All right, so that's a Fourth Amendment violation. That's intruding on his privacy. You can't just go in and ask for a search warrant and do like a catch-all or a wide sweep, as he said. Right, so the search warrant was emailed. Hello. She's back. Just a minute. Ooh. Hey. Hey, how's it going?
Sorry, my service. I don't know what's happening.
It's okay, no problem. So we're in the middle of this AT&T one, and I think Joe Logston wrote this one. He's talking about the state doing the application for the search warrant as a wide sweep, right? And that being a Fourth Amendment violation. So the search warrant was emailed to AT&T, and there is no indication the affidavit accompanied the search warrant. So also just a bit shoddy as well. Yeah, there is a Sleuthia Goosey here. Indeed. And hello, Lindsay. Good to see you. The process described by the state as meeting the criteria of State versus Teal simply does not exist. It is incorporated objection in its incorporated objection to motion to suppress Apple warrant. The state indicates that the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. See Apple objection, page 5. Further, the state offers that the effect of this is that the affidavit for search warrant and appended exhibit A cure any supposed deficiencies in the naked warrant. Oh, naked warrants are bad. We don't want naked warrants. See Apple objection, pages 5 to 6. And an officer sitting at a computer executing a search warrant by submitting it electronically to AT&T and having the affidavit for search warrant in his hand is different than an officer being physically present when executing a search warrant and having the affidavit for search warrant available for reference. Okay. In response to the state's argument under defendant has not demonstrated the search warrant affidavit contain intentionally or recklessly false statements or omissions. Well, that's a bit of a Doug Carter argument. We made mistakes. We didn't make any mistakes that we knew were wrong when we did it. Defendant refers the court to and hereby incorporates defendant's reply in support of defendant's motion and memorandum in support for Frank's hearing. Ooh. And reply in support of motion to suppress genetic information. Okay, so this is part of what's going to be in the Frank's hearing. In response to state arguments under, I just reread this so I can understand. In response to the state's argument under defendant has not demonstrated the search warrants affidavits contain intentionally or recklessly false statements or omissions, defendant refers the court to and hereby incorporates defendant's reply in support of defendant's motion and memorandum in support for Frank's hearing. Okay, so this AT&T warrant seems to be one of the things that is going to be brought up at supposedly a Frank's hearing if it gets granted. And Frank's hearing is about there being potential misconduct by the state or by a particular officer, for example, Payne. And if that's the case, then there would have to be something done that was not unintentional, so intentional. So that's why it says contain intentionally or recklessly false, right, Sleuthy?
Yes.
Yes, indeed. Okay.
Which is really difficult, like super difficult.
Yep, indeed. Frank's hearing. There's a watermark on the sheath. What sheath? Where's there a watermark on the sheath? Can I just ask you, with the Frank's hearing, do you think that it's only aimed at Mr. Brett Payne, or do you think that there are others that are going to be implicated?
I think it will largely fall on Brett Payne, but I think maybe the guy who serves the warrants, like the electronics guy, he might be included. But I think in general, Payne is the one who... Oh, who is the other guy? There was another one that also wrote one of the affidavits.
Mowry?
No. Let me go see.
Okay.
Blaker.
Yeah, you're right. Oh, that's
So,
right.
yeah, so Blaker might be, but I still think that Payne's going to be the majority.
He's going to take it. And DB, yeah, you're right. That's the standard to win a Frank's motion. Intentionally reckless or material omissions.
Yeah, and it's hard.
Yeah. And the judge has done nothing about this, or nothing on the record with documents that we can see in regard to the Frank's hearing. So, I mean, we're still waiting to find out what's going to happen with that. Then his gun ended up not being loaded. Oh, sorry, you guys talking about Richard Allen. That's all right. Talk about what you like. All good. Payne will say he relied on balance Maori, etc., to get himself out of trouble. Well, they tend to do that.
Yeah.
They tend to sort of pass it around, go, well, that wasn't my job at the time, it was somebody else's, and I don't recall, and etc., etc. They love doing that kind of thing.
It's really
But
I was just talking about this earlier, that it's really difficult to prove when all they have to say in response is, at the time that I wrote it, I thought it was true. So
that too.
at that
Yeah.
point, you have to prove that at that time they did not think it was true. And it's hard to prove what somebody was thinking or not thinking, you know?
Yep. Absolutely. Absolutely. And with, especially when you're dealing with an organization, right? And with a state organization, there's a lot of people involved and a lot of moving parts and times and dates. And it was a while ago now. And you can easily just pass the buck and not even look like you're throwing someone under the bus. Just go, well, this was my role at the time. My role was to do this, this, and this. I did this to the best of my ability, and that was the outcome. Done, right? And there you go. You walk off the stand, and you're finished. And then the next person comes onto the stand, and I did this, this, and this. I don't recall these parts, and they walk off the stand, and really no one ends up taking responsibility. It's done. And yeah, end of story. It's impossible for the defense to counter that, because how can one person possibly take the fall for anything? There's no one person that is responsible. Okay, now we're going to go and have a look at. Did we look at the AT&T one? No, I don't think we have. Oh, okay. Oh. Google. Google. All right, we'll have a look at Google, and then we'll have a bit of a chat. All right. So, reply to state's objection to defendant's motion to suppress memorandum in support re-Google, warrants dated. I always see dates the other way around. I'm Australian. So it's the 3rd of the 1st, 2023, and 24th of the 1st, 2023, and 24th of the 2nd, 2023. Okay, has anyone reviewed franks that have been successful? That's a great question, CH.
Yeah, the original one. Franks v. Delaware. You can look that one up.
Well, that's a great answer. Yeah, one worked. Comes now Brian C. Koberger by and through his attorney of record and submits the following reply to the state's objection to his motion to suppress and memorandum in support re Google, warrants dated 3rd of the 1st, 24th of the 1st, 24th of the 2nd. The words proof upon earth. Oh, hang on, have we? Oh, okay. Sometimes I wonder if we're looking at the same thing because they do a bit of copy pasta, as they say. The words proof upon oath are not synonymous with the affidavit for search warrant is hereby incorporated. A non-particularized general affidavit in support of a search warrant held in the hands of law enforcement, which never accompanied the electronically served warrant, cannot be relied upon to validate a warrant. The warrants never directed law enforcement to exclude any legal information obtained in support of particularity. All contents of the Google warrant returned must be suppressed. The warrants were general, and the affidavit was not incorporated into the 3 warrants or served with the warrants. So the 4th Amendment to the United States Constitution states, oh, here we go. Love a bit of quoting the Constitution, the right of the people to be secure in their persons, houses, papers, and effects against the unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmations, and particularly describing the place to be searched and the persons or things to be seized. Article 1, Section 17 of the Idaho Constitution is virtually identical to the 4th Amendment, except that oath or affirmation is termed affidavit. That's interesting. Okay, so the Supreme Court has acknowledged that a court may construe a warrant with a reference to supporting application or affidavit if the warrant uses appropriate words or incorporation. All right, so what's happened? The warrants contain no language that the affidavit was incorporated. So again, this is just like the other one we were just reading, right? The HET one. There was no affidavit. In misguided fashion, the state asserts that there is no requirement for specific language and relies on Adamczyk versus State, which upheld a warrant where the opening paragraph of the warrant unambiguously referenced the affidavit and sworn testimony of Detective Sellers as the basis for the warrant. 163 Idaho 114, 2017. No such language exists in the Google warrants. The word affidavit is not mentioned or incorporated into the warrants. The affidavit of Detective Brett Payne swears that Detective Mowry, that's Mr. Screenshot, everybody, served the warrant. Mr. Snipping Tools. I use Mr. Windows Snipping Tool. Exhibit D Google Memorandum. The email between Mowry and Google reference a warrant. See Exhibit F Google Memorandum. No return documents reference the affidavit in support of search warrant as having accompanied any of the Google warrants when they were served. Okay, so nor does the state produce such records in its objections. Google warrants is the newest Google product. Yes, why not? These people need it. The process described by the state as meeting the criteria of State versus Teal simply does not exist. And again, this is what Jay was writing earlier. Pretty sure this is Jay here. In its incorporation objection to the motion to suppress Apple warrant, the state indicates that the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. Okay, so just to put it into a nutshell, basically, these digital warrants that they have done were really goddamn shoddy. Really goddamn shoddy, and they violated his Fourth Amendment rights. This is a death penalty case, guys. This is really important. They're trying to kill a man. They're trying to kill a man, and they have not crossed their T's and dotted their I's at all. This is shocking. And it's important, right? It is very important. The
I'll tell
search
you
warrant
what.
fails. Yeah, go.
When it comes to the search warrant for his parents' house, so this was long ago before Andrea Burkhart started like covering this case.
Yes.
I was pulling all the stuff and I sent her, she knew nothing about the case really.
Yeah. Yeah.
And I sent her the affidavit for the search warrant of the house and the car, and his apartment and everything, all the things.
Yep.
And the first thing that she said to me after she reviewed it was that it doesn't meet the particularity requirement, meaning when they say what evidence they think they're going to find if they're allowed to search such and such a thing, they have to be specific about what things they think they're going to find. So saying any and all evidence of a crime is not particular enough because what crime?
Yeah.
So if you think that you're going to find evidence of a crime that happened to be like a shooting, with a particular gun, you found the bullets, then that would be included in there that you think you're going to find such and such a gun, which shoots these particular bullets. And so it's funny to see now, 2 years later, all of this coming around full circle with what she literally said to me 2 years ago about it not being particular enough.
Particular. Yep. Yep. It's vague and it's broad. It's a wide sweep, like the document said. I'm not surprised that she saw that immediately. But yeah, you're right. Now here it is in these objections. Sleuthy, sorry, before I get you to answer, I just want to thank DB for the 10 subs. 10 subs. Thank you very much, DB. You are an absolute legend. And chat, look who's here. DB's here. He is a bit of a legend in our chat here because a big contributor to Hearsay for Days. This guy trolled Jenny C in a big way. Love you, mate. And yeah, they can't get a blanket warrant. No, they cannot. Okay, so Sleuthy, I wanted to ask you, just in regard to this whole thing with like what I started the stream about earlier. I don't know if you were here, but I wanted to ask you about this whole thing with the lack of experts. So what the state are playing around with now, with not coming forth with 20 of their experts reports, right? So they're late or they haven't provided 20 reports from their experts, and they don't have expert testimony for a DNA expert at all, right? What do you think this means?
Wait, say it again about not having a DNA. What do I think it means? They don't have a DNA expert listed in there?
Yeah.
Uh, I think it could be that their DNA expert's just going to be like a cop at the lab. I think that could be so. I think a lot of their experts might end up being just cops.
Yeah. Imagine if it was just a cop. Like, imagine if it was like Maori with his window snipping tool.
Yeah, I mean, people don't realize how many experts testify against defendants in trials that are like just cops that took a class sometime.
Okay.
Isn't that crazy?
Well, I know, but okay. So here's the thing. Do you agree? I people are saying this on the Reddits and in the comment sections and things, and I'm just not sure. But it seems to me that the state has dropped the IGG, right? So they're not fighting back on presenting IGG at trial.
Well, they've always
Right?
said that they have no intention to bring that in because I think it causes more problems than they can combat. But that still leaves the DNA that you compared to the trash DNA, and then that you compared to Brian Koberger and the sheath. You still would need a DNA somebody.
Yeah, right. So it's kind of like foundation. It's like, well, how did you get it? Right? So it it leaves the door open for the defense to be like, well, so see this touch DNA that you've got, and we're bringing in real experts here. How did you get it? Like, what? To show us the process of how did you arrive at this? And if they've got nobody over on their side on the state who can really explain it, and there is no one to testify about the IgG process either, then don't they look kind of stupid?
Well, I think they would have a difficult time explaining without the IgG how they determined, let's say on the 20th, that Brian Koberger had anything to do with it. Because
Yes.
you have to think it's what prompted them to steal the trash, right? They got that name. It's what prompted them to start watching him. It's what prompted them to steal the trash. It's what so. But I don't know that those things for the jury they might need an explanation. But I don't know legally if they need an explanation because it's a tip. You know what I
It's a
mean?
tip. Yeah. Yeah. Just the tip. They only
I
need the tip.
personally, I'm against it. I mean, I think that IgG is great to find uh, identities of cold cases and of remains that you find that need a name and to be returned to their families so they can be properly put to rest. Like, yeah, I think all of that is great. And, even if I guess if you're going to use it to solve a crime that's however many years old, decades old, I just, and it's funny because Teresa, I know she's like all into IDG. I like the idea of it for identifying people, but I do not like identifying the remains of people so they can so they can be laid to rest. I don't like it to copy a tiny piece of DNA over and over and over and over again and put it in a system with no warrant and make a tree and then decide who lives close by that might be guilty. I don't like that.
No, I feel that that's an intrusion of privacy.
At the very minimum, they should need a warrant.
Yeah, absolutely. Absolutely. And they didn't at that point, right?
Yeah, they still don't need to.
Yeah. No. And yeah, it's just okay. I don't know how much you know about the Zachariah Anderson case, but this is total deja vu for us who know that case.
I don't know the ins and outs of it, but I believe I watched like maybe one of his trials. Has he had more than one?
No, it's only one. He was convicted on a pinhead of transfer DNA.
But was it the
And
girlfriend or the baby mama who like they weren't together anymore and it was the
yeah,
boyfriend? Okay, yeah. I mean,
yeah,
I did
that's the
see
one.
it.
That's the one. Yeah.
Hmm.
And yeah, their expert witness was didn't even have to give any figures, didn't have to say it was 1/1 octillionth or anything like that. Only was made to say by the DA when questioned that it was within her, what was it? Within scientific
Reasonable certainty or whatever.
That's it.
Yeah,
Reasonable
it's like
certainty. Yeah.
it's like what you think is reasonable might not be what I think is reasonable.
No,
So what
no,
does that
no.
mean?
But that was 100% what made him get convicted. And there was nobody in that case. Nobody was found. Nobody was found.
And there was something about his minivan. It had like a piece of carpet that was pulled out or
Yeah,
something. And then they had the
yeah,
little girl testify against him, saying that he was like watching mom through the window. Yeah, I saw all of that.
yeah, yeah. Absolute travesty of justice. Complete ridiculous. Like Richard Allen level. And this is the thing. The jury heard DNA, right? And they convicted him. It's that simple. And I am
It's scary.
it's so scary, right? And they even heard blood. They heard that there was blood. It wasn't blood, right? That pinhead wasn't blood. It looked like blood. And the only reason that the state's experts said it was blood was because it was the right color to be blood, right? But there were other stains in that car that were the same color and weren't blood.
Well,
Yeah,
look at Koberger's apartment. They took samples and swabs of like, I don't know, 20 plus stains that looked like blood. None of them were blood.
yeah,
So, and
exactly.
I've never sat down and made like a pro and con list for professional jurors, but I gotta say, like the more that I see, the more I consider that might be a better way to go than just people that live in the area because it's scary, really.
I am unfortunately 100% resigned to the fact that if Mr. Koberger goes to trial, he will be found guilty.
Yeah.
Unless there is some divine intervention,
I don't think
he's going to be
anything's going to
found guilty.
matter than them say that DNA, no matter what kind of DNA it is, on the knife sheath matches only one person, and that's
Yeah,
Brian Koberger. I think
that's
that's all
it.
they're going to need to
So,
know.
unfortunately, there will need to be some sort of Alec Baldwin kind of moment um, where there is the judge is going to have some balls. The judge is absolutely going to have some balls, and he's going to have to dismiss this. There has to be a moment where there's just too much evidence against the state and what they have done. There's too many discovery violations. There's just too much shenanigans, and the defense puts forth a motion to dismiss, and the judge calls it. It has to happen eventually. If that is his only way out of this, Brian Koberger, it's his only way out. So he has to, Judge Hitler has to be a Judge Summer, basically. That's what has to end up. That's the only way out. Chances of that?
Super slim.
Yeah, I know. But I mean, I also believe he's factually innocent. I believe this guy's factually innocent.
I think that for me, my problem is I'm struggling with the concept that other Americans don't have the same level of burden that the state should meet in order to pluck other Americans off the streets and out of their homes and put them in prison and convict them and sentence them to life in prison. I think that others need to raise their standards for what the state needs to prove, and until that happens, if you can go into a trial and the only thing that you hear is, let's say back when what's his face, one of the serial killers, part of what convicted him was bite mark evidence. Well, now that's like trash. Like they don't even do it anymore. They can't, because it turned out to be garbage. So if all they hear is, well, that we matched the bite mark on Hella to Sleuthie's mouth, and the jury's like, yep, yep, that's great. I don't care that it also could have matched Joe Schmo's down the street's mouth, and I don't care that so and so was also at the house and has no explanation for why their DNA was there, but the person that's sitting in front of me is the one that they're saying matches the bite mark. So let them figure it out on appeal. And that's
100%.
not the way to think, because it is so incredibly difficult. It is so easy to arrest you, number one, and then incredibly easy to convict you, and it shouldn't be. And it is extremely difficult to get you free.
Oh, look, and okay, so just onto a different topic slightly for a moment. Appeals, as my friend Andrew Branca says, appeals are for losers, unfortunately, right? And that's a sad way of putting it, but it's true. They take years, and they very, very rarely are successful. I think Richard Allen has a fair chance, based on the facts, of winning an appeal, but it will take years, right?
Yeah.
So,
well,
yes.
And you're also at a disadvantage, more so than you were at trial, because you no longer have the presumption of innocence. You've been convicted.
Yes.
So
it's the other way around.
So you're at an extreme disadvantage. Plus, on top of that, you have to consider, we were talking about this about Richard Allen specifically a night or two ago. I can't remember. And I was just appalled at the thought that, okay, so they messed him up in his brain, right? And it caused these confessions. I'm certain of that. And they could restore him to a little bit of sanity. I don't think that he's back to his baseline. But what if he spends the next 5 years at Westville, the same place he lost his mind at, and he is granted a new trial, and at that point he's not competent to stand trial? What if he lives and he's just so permanently messed up from that facility that he's no longer competent to stand trial? Well, guess what?
Yeah.
He's staying where he's at.
He stays there.
So that's scary to me. That's extremely scary.
It's very scary. I mean, it's a very high bar to not be competent for trial, but still, it is scary. It's scary that could happen. I'm more worried that he's not going to make it. Personally, I'm really worried he's just physically not going to make it. But I did want to say that regarding the appeal process, because it takes so long, because it's such a grind, it's expensive, there's just so much involved. But supporters, guys, stick with it. Everybody, we're in for a long road. We're in for a really, really long road. There's as someone has been found guilty, the narrative out there changes, people feel really justified to continue to speak all sorts of myths about people, to say that he definitely did this, he definitely did that, he's a monster, he's a pig, he's all this sort of stuff. And because he's been found guilty now, they feel really justified in doing that. And the all of the theories, I suppose, that we can have about the other potential culprits, we're all going to be called conspiracy theorists now for years. And as time goes on, we'll us who are supporters of Richard Allen or Zachariah Anderson, we get more and more outcast. So you have to be really strong and stick with it. And be ready to put out the fires when they come up, because they will. They'll keep coming up.
Yeah, and also, back when we were talking about like putting them in a position of where they have to try to think about what someone was thinking, you have to prove what someone was thinking at the time, or what something would mean to them, how significant it would be. The same thing happens with the appeal, right? So you bring them all this information, and essentially what you're trying to do is tell them that this information that you're writing there, if the jury would have known about it, or it had gone a different way to the jury would have heard it, then they would have instead voted not guilty. They might have voted a different way. Well, how do you prove that they might have voted? Like, how do you, Helen, know what the jury might have wanted to hear?
I hate that argument, right?
Mm-hmm.
It's just like appellate courts are all like, oh well, that's harmless error because the jury would have voted that way anyway.
Yeah, like
It's just
say you
like,
lay out all the third party
please.
stuff. You lay out all the third party stuff, and then an appeals court says, well, let's say we agree that all of that stuff should have been put in front of the jury. They should have been able to hear all of that, but it wouldn't have mattered because they had the confessions. Well, how do you know that?
Please. It's just,
if you're not the jury.
It really is infuriating when you hear things like that. And people have been through a trial already. They've been wrongfully convicted. If this person really has been wrongfully convicted, and then they go through all of that, and then they get up to the appellate court and then hear that, it's just such a kick in the gut.
It is.
In regard to like the Innocence Project, people talk a lot about the Innocence Project. What we've found with Zachariah Anderson is that they tend to only look at cases that have been rejected by the appellate court once. So I suppose that's one consolation for any case that has had that terrible result. Maybe the Innocence Project may be interested in taking on a case that has lost their first round of appeal. So some more high-profile cases they do look at before they've been to their first round of appeal. But yeah, we did strike that with Zach. And Lokong, you are right, and I should have noted that Zach did go to trial and have a mistrial. So there were actually 2 trials, but the mistrial happened very early on. So he had to go back to trial a year later, I think it was. So yeah, his trial was March 2023. Yep, so nearly 2 years now. Nearly 2 years. And yeah, we can't wait to see him walk out of prison, because he will. We're being positive about that. Yeah. Okay, guys, thank you so much. It has been really awesome to talk to you, Sleuthy.
We have to talk again.
We do. We absolutely do. I gotta say, I'm a little bit of a fan of yours. I have been following you for a while. You are just the GOAT when it comes to documenting and following all of these cases, especially Brian Kroberger. You've been on it since day one. And I gotta say, thank you for all the work that you've done. And with the Richard Allen case, good on you for sticking with that and getting all that information out there. It's hard work. I don't know how you do it in between your day job and kids and things like that. So
I don't deserve it, but I appreciate it. I like to gather. I would prefer to be engaged in conversations that are based in actual factual information, and we can speculate based on that stuff. But
yeah,
I got extremely tired of just total speculation conversations with no basis in any type of fact whatsoever.
absolutely. And one more thing before we go, and that is that this is a community, right? And we support one another. We don't shut people down because they comment on each other's streams,
Yeah,
right?
yeah.
Yeah, exactly. And so I just want to say that uh, I don't approve of the fact that you had your streams removed the other day. Have they been restored?
They have not, and I appreciate that. I
Yep.
thought, regardless of if somebody didn't like what was said, that's, in my opinion, totally irrelevant. People say things about me I don't like all the time, but like,
Yeah.
there's nothing I could do about it. Um, people stealing things and making money off of things well, people have done that to me too, and I just don't
Mm,
care. So it just seemed really odd to me to have taken that down, especially when you consider, well, does this person have a audience that would not come and watch my channel? Like,
mm,
if not for this person that's playing my interview, would these
mm,
people not hear the information that I'm trying to put out there? And the answer is usually yes. And so,
mm,
what is your purpose? Do you want the information to get out there to as many people as possible, or do you want everyone to only get it from you so you can make money from it? So,
mm.
um, I think that it was unfair, but that's fine. I did the reversal request or whatever, the
Yep.
counter or whatever. I don't know anything about YouTube, but
Yeah.
she had 10 business days from that day to either show YouTube that she's taken legal action against me in federal court where I live, or they're going to reinstate it. So hopefully they reinstate it. She just doesn't
I
do
think
anything
they'll
about it.
reinstate it.
I
I
think so
think it's
too.
I think it's a flex, basically.
Well,
But
it's a now for 10 days, 10 business days, no one can watch it anywhere but here. You see what I mean?
and that's a lot of views.
Oh, 100%. That's a ton of views.
Yeah,
If you're
and
the
I
only
think
one that
that
can show it.
that's the point. That's the
Yeah, I
point.
think
But you
so.
know what? I really love what you did with getting the transcript. So we can read it if we want.
Oh
So
yeah,
that's
I can't wait
fine.
to do that. I have that one and the murder sheet one.
Yeah, nice. Are you going to do a dramatic reading of it?
I hope so. I hope Teresa will do it. And then there was another article that came out today.
Yeah.
Holman talked to another person with more outrageous things he was saying. So
Did he now?
yes,
Oh,
ma'am.
well, there
Hmm.
you go. I can't wait to watch it. So, guys, make sure you subscribe to Sleuthy, and also Criminality. Teresa there in chat. Hey, how are you? So yeah, make sure you subscribe to both these channels, wonderful channels, Sleuthy and Criminality. I can't wait to hear the readings of the Holman interviews. Mr. Glory Holman, the wonderful ham sandwich eater. Yeah, very
Ham
much interested in
sandwich
that.
eater. You know you're a dingbat when you're standing there with somebody that's literally saying something offensive about you, and you're just like, smile. You're not going to tell me it's because he doesn't care. I think he just didn't get it. I think the joke went over his head.
Yeah, no,
Lord have mercy.
it was classic. All right. Um, cool. All right. Thank you guys so much. It's been awesome. Sleuthy, you're amazing. Everyone in chat, thank you so much for being here. Keep an eye out. The 23rd is going to be, I can't wait. I'm more excited for it than I am for a trial, honestly. But yeah,
All the pretrial stuff is always way more exciting. It's where everything gets, all the pretrial motions, the pretrial hearings, it's where everything gets duked out. They fight the battle because it's really what's most important, what's going to get to
yep,
trial and what's not. And so it's always the most exciting.
yep,
I think people bypass it because they don't know.
yep, 100%. But I well, sometimes when I watch the trial, I'm just like, I wonder what happened before. Like, why didn't we get to see all the stuff beforehand? Like, if it's a good
This is
trial,
it. Yeah.
yeah, I know. And yeah, like we're watching the Melody Faris one in our spare time on this channel every couple of days, and we're about a week out at the moment because we had a bit of a Christmas break. But
Yeah.
I wish we'd seen some pre-trial stuff on that. It would have been so interesting.
Yeah, but see,
Um,
then it gets frustrating, just like with like Richard. Well, we didn't get to see Richard Allen's trial. That would have been
yeah,
great, but it gets frustrating when you know all the things that don't get in, and you're like, so you're torn. Yeah, either way, it's
yeah. I know, I know. I just, such a shame. Thank you guys so much. All right, so it's time for the song. I don't know if you've ever heard my song.
I want to hear it.
So,
Of course, I've heard it. I pop in here.
I know you do actually. Thanks for that. All right, I'm a little bit embarrassed. All right, let's go.
Don't be a
All right, the Hello Rock. It's time. Let's go.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Darby and she dances sometimes. The words are always so loud and because she's an 803. To be excited ignorance. Her cat is